Listen Up with Jim Potts. Listen up, business owners, CFOs, human resource managers, and all managers and supervisors. Jim Potts is answering and addressing your questions and concerns, helping you stay out of court. Furthermore, please be advised that Jim's answers are not legal advice and are only intended as a guide based on his years of experience. The phone lines are open, 1-855-4-J-POTS. That's 1-855-457-6887. You can also email us at listenup@jameswilliampottsllc.com. Ready to listen up? Here is Jim Potts.
Hey, Jim Potts, how you guys doing today? I hope all is well out there. Hey, a few weeks ago on my blog, I posted some of the new laws that were signed into effect by Governor Brown. And I've gotten a number of questions and inquiries about them. And I want to just go ahead and cover some of those again, maybe just in a little bit more detail. And they've been asking me my opinions about some of these things. So quite frankly, it was easier to put it on the podcast than it is to write an opinion about every one of these new laws. Some of these actually updated laws that were already in place. But let me start out with what's called AB 1676, which in fact is the Equal Pay Amendment. And this bill basically amended California's Equal Pay Act, which makes it unlawful to pay employees of one gender less than similarly situated employees of the opposite gender, to expressly provide that prior salary alone is not sufficient. Let me tell you something. First of all, there's a lot of laws out there, and I don't want all the women writing to me and being upset with me, because that's not what's intended by this. I mean, I know with the political candidates, there's one in particular that keeps discussing, equal pay for women, etc. There are so many different laws on the books for that already, and this is another one. I'm not saying whether these laws are right or wrong. I can understand how they started out to make sure that women are being paid equally. So there's absolutely nothing wrong with that. I think that my personal feeling is that people should be paid, based upon their qualifications, not based upon their gender. So I'm all in favor of that. This new bill amended the Equal California Pay Act, and it was already in law in California. The law was already enacted a year ago, maybe 2 years ago now, where an employer, if they give additional compensation to a male employee and there's a female employee who's doing the same exact job, then the female employee, and let's say the male employee gets an increase, the female employee can go and question that and ask why, that individual, why the male employee, her counterpart, if you will, was given an additional compensation amount of whatever it was, versus what she's being paid. Now, part of the inquiries that I've gotten regarding that one is, well, can we have a policy that says that people cannot discuss salaries? Because if we can do that, then we don't have to worry about this as an issue, because there's a lot of factors to go into why one person may get additional compensation and another person may not get the same exact amount. And that part is really true. That's what makes this, in my opinion, a very complicated law. Because we've had situations where women have gone and demanded, to know why, Joe got an increase and she didn't, as an example. Well, first of all, in California, even though the question posed was, can we have where the salary is confidential, so people can't discuss it, that's illegal in California. So you cannot tell people in California, employees in California, that you will not discuss salaries, you will not discuss bonuses. It comes under the California Labor Code. So having said that, that means that if employees choose to discuss their increase and they do so, and we'll just say a female employee finds out about that, she can in fact go and challenge why she got it, why that person got more than she is being paid more than she is. Now, this amendment, though, changes it even a little bit more, because what happens is the amendment states, and the reason for the amendment was that it expressly provides that prior salary alone is not alone a sufficient justification for a pay disparity. So what they're saying by that is, let's say the person was working at, I'll keep it simple, at $10 an hour, and this other person was making $11 an hour before, so there's a difference for different reasons. And an employer says, well, the reason why the person is getting the additional amount of money is because they were already making more money. This bill is amending that to say that's not good enough. You're going to still have to explain why this person is making more money than what the other person may be making. So you can't use prior salary alone as a justification for a pay disparity. All right? And I know, because I have a lot of clients out there, this creates a nightmare sometimes, but the focus is a right one, although I will say that it does create problems, because there are people out there that will challenge every nickel and understand sometimes that maybe the quality of their work maybe is different from the quality of somebody else's work. So as what I tell employers, as they should be able to do anyway, is to justify why somebody's not making as much as the other person. All right? Okay, let's move on. There's another one that came out called SB 1001. And basically it's a remedy for unlawful verification of right to work. Now this bill adds to the labor code. A specific labor code section is 1019.1, which makes it an unlawful employment practice for an employer in the course of verifying an applicant's authorization to work. Right? There's several things I want you to keep in mind. One, requesting more or different documents that are required under federal law. What does that mean? That means that even though the person has given you some documentation, the federal law on the I-9 sections A, B, and C, you require something more than that. This bill is telling you that that's illegal. All right, you cannot do that. Number two, refusing to honor documents tendered that on their face appear to be reasonably justified. Now that word reasonably, in my opinion, can create a nightmare, because again, the feds don't expect employers to be police officers. So if you get some documentation, the documentation looks reasonably correct to you, then that's okay. Just accept it and move on. Now remember, there's no law in there that says that you have to keep copies of those documentations, by the way, for the I-9s. The person that's from the company representative that's signing off on the I-9 is attesting to the fact that they saw the documents. So that's good enough. That's all you have to do. You're not expected to be police officers. So don't go on a witch hunt behind some of this, even though you may think that there's something, seriously wrong. This only says reasonably genuine. If you think that if it's unreasonable, it really does not look right, then that's fine. Number three, refuse to honor documents or work authorizations based upon the specific status or term of status that accompanies the work authorization or the authorization to work. Look, if you know that when you look on that document, the document says it expires in 30 days, 60 days, 90 days, whatever the date is, just set a particular file and put in there, because the feds are going to require that you keep your I-9s on file for your current employees going back 3 years, 1 year for terminated employees. So let's just deal with the first 3 years. Jim comes to work in January. At the time he shows documentation, whereas at that authorization to work, a piece of documentation expires in 6 months. All you have to do is 2 months before that, let Jim know that in 2 months your documentation is going to expire. We need you to be able to give us the updated document once you get the new one. And then all you do, take the original I-9, look at the bottom of it, or maybe it's on the back of it now, but there's a spot for it that says that you updated the I-9. So that's what you do. All right. Number 4, attempt to reinvestigate or re-verify an incumbent employee's authorization to work using an unfair immigration-related practice. An applicant or employee subject to a violation of this law is entitled to file a complaint with the Department of Labor Standards Enforcement, that's the Labor Board, and recover a penalty of $10,000 per violation. Now hear me on that. It says attempts to reinvestigate or re-verify an incumbent employee, that means one that's already working for you, their authorization to work using an unfair immigration-related practice. They can take you to the labor board and get 10 grand. Now look, this one to me, I think is very, very bad. And I'll tell you why. Since these people are asking for my opinions on some of these. With this one, what happens when it doesn't address the issue? What happens when the employer gets a no-match letter from the Social Security Administration, meaning that you sent the information in, and now the Social Security Administration is writing back saying, "Hey, we've got somebody else's name on that, that's using the Social Security number." Now, what would the employer have to do? Why wouldn't they have to re-verify that? So I think that's okay, because this only speaks to the issue of using a, let's see exactly how they said it here, an unfair labor practice, okay? Immigration or related practice. So I don't think that would be inappropriate to do that. I had a call the other day where, in fact, the employer received a letter that an employee working for one of my clients is using their Social Security number. And the employee had only been working for the employer for 2 months. Now, what does that tell you? That there's an issue there. Now they go to the employee, they need to re-verify that. They need to go and ask them what's going on with that. Because now they've gotten a letter. So to me, there's nothing wrong with going back to the employee under those circumstances saying, look, we got this letter. Here's this particular person saying you're using this Social Security number. I don't think there's anything wrong with that. And in this particular case, what happened? The guy admits that, in fact, he it's not his Social Security number. Well, he's been there 2 months. So at this point, in my opinion, the employer's got a choice to make. Because now you know that he's admitted that he's illegal and he's working for you. I mean, that's a $10,000 fine and some other issues that can be associated with knowingly employing somebody that doesn't have a right to work in this country. So at any rate, that's SB 1001. Now, let's take a look at AB 2337. And that's Notice to Employees of Rights Concerning Domestic Violence or Stalking. Look, there's already laws in place in California regarding this business about domestic violence of any sort. The current law provides that employees who are victims of domestic violence, sexual assault, and or stalking the right to take time off from work on specified circumstances. So right now already they could take time off for court appearances, doctor's appointments, psychological types of appointments, etc. So don't stop them from doing it. They're able to do it. Now, this law, as has been changed, will now require employers to give new employees written notice of these rights upon hire and to provide notice to current employees upon request. So what they've done now is taken this to another level, and even though you have it if you have it in your employee handbook, you're pretty much okay. If you don't have it in your employee handbook regarding their rights concerning domestic violence, then you need to create a policy that you can put in the orientation package as an example. Now, the bill also requires that the labor board, that the labor commissioner, by July 1st, 2017, prepare a form notice to employers to use to satisfy the requirement I just told you about of this new law. So employers are not required to comply with this notice until the Labor Commissioner's notice form is posted on its website. So what I'll do basically is keep you informed as to when, and look for the blog on that. That'll be on the blog, and I'll let you know when that form has been completed and appears on that government website. We'll probably take that form and put it on our website as well. All right. Okay, the last one that I want to talk to you about, and this one I saved for last as the goodie. SB 1063, equal pay again. Now, I just talked to you about the equal pay based on gender. Now is what they've done is given an equal pay for race and ethnic background. Now, hear me on this. This bill expands California's equal pay law, which currently prohibits wage differentials based on gender, to prohibit employers from paying employees of one's race or ethnic background less than similarly situated employees of a different race or ethnic background. Do you have any idea, since you're asking for my opinion, how much litigation is going to come out as a result of that? Look, once again, there are laws already in place, but now is what you're doing is telling employees that if there's an amount of money that's different from somebody else of another race or ethnic background, that you can challenge it. This is what the work environment already is. People already get upset about these things. And as I stated in California as an example, you don't have to keep it confidential in terms of, you can't tell employees keep it confidential in reference to their compensation. So now is what the state is saying is that we want everybody to be able to challenge everybody's pay. It's going to create a nightmare for employers. All employers aren't out there making decisions based on pay, based on somebody's race. Now, I know that may seem to be the focus from those who want to create these kind of laws, but what's the percentages of that? 10%, 15%, 20%? I would love to know what the actual percentage is, because I would bet that probably 85%, maybe even 90% of employers, they're not doing this based on gender. I'll even give you a higher number, 98% maybe, that aren't based on doing this based on somebody's gender or based on somebody's race. All this is going to do is create more litigation and backlog the Superior Court or the mediation or alternative dispute resolution process even more. It's going to create a nightmare of morale issues for employers. You're going to have employers second guessing everything to the point where mistakes are going to get made. At any rate, this is where we live. This is where it is, and I think this one is going to create a lot of problems. There's already laws out there regarding gender, like Title VII or the Fair Employment and Housing Act, regarding making sure everybody's being treated the same. Adding one more, law, and one like this that could create all this litigation is just going to create a nightmare, in my opinion. All right, with that last comment, it's time to close out this segment. But let me remind you, you can also hear us on Facebook at Listen Up. Just look for Jim Potts, Listen Up with Jim Potts. And as a reminder, we take calls every third Friday. We can be reached at 855-4J-POTS or 855-457-6887. Or you can email us at jameswilliampottsllc.com. Okay, I'm Jim Potts. I will continue to fight the fight. Thanks for listening.
Thank you for being a part of Listen Up with Jim Potts. We take your calls every third Friday at 10 a.m. Pacific Standard Time for your questions and concerns. Call us at 1-855-4J-POTS. That's 1-855-4J-POTS. Again, that's every third Friday at 10 a.m. Pacific Standard Time at 1-855-4J-POTS. Like us on Facebook, subscribe to us on iTunes, and link up with us on LinkedIn. You can also email us at listenup@jameswilliampottsllc.com. Until next time, make it a great week.